So this year, the getting credit part, as you know, includes two main sections. One is about the legal rights, second is about the credit information. So we have, for the concerning the first part, we have the functioning state registry of encumbrance of mobile property, which is a NOx-based system. It's electronic, online, accessible to everyone. It's working 7/24. Last year we scored 8 out of 12, but this year we believe that we will have a maximum point that I will go in detail further. Then regarding the credit information, the last year we scored 8 out of 8 due to the creation of the credit bureau, which is a credit registry that collects the positive and negative data on both individuals and firms, and also these credit suppliers, including not only the financial institutions, but also the utilities, mobile operators, and other credit information suppliers. So as for the statistics, I would like to give the brief information. As you know, we have a second presentation on this on the second half of today in TIMSA. So the state register for the encumbrance of mobile assets, that's shortly called collateral registry, now is functioning for more than 1 year. It has more than 33,000 notices. It has 641 users. They are mainly banks, individuals, non-bank credit institutions, lease companies, credit unions, and other unions. So on the right part, maybe you cannot see clearly, then we will, of course, give you the presentation. You can see that this is the statistics of the notices according to the type of the collateral, so that they are mainly consumer goods that have been collateralized in the registry. Second is the furniture, then jewelry, and then other movable assets. As per the AKB, by the way, which means Azerbaijan Credit Bureau, this is the statistics of the Credit Bureau. The last year we had submitted credit scores. It was new, so it was around 5,000 or something. And now, as you can see, the inquiries for credit scores is more than 800,000 inquiries. So if we calculate it by one, so it has been changed, increased 42 times per month, so reaching at this number. So again, the mainly users of the credit bureau is the banks. Then you can see that we have 30 banks, 14 extra banks that are under liquidation, 48 MBCIs, 22 insurance and reinsurance companies, 6 utility companies, 50 courts, and 1 other organizations. So last year we made some reforms on the getting credit part. This is the mainly amendments to the civil code, and also the amendments to the law on encumbrance of mobile properties. Cabinet of Ministers adopted the new decree that listed the information systems through the state encumbrance notices can be integrated to the collateral registry automatically. So they made some amendments to the law on credit bureaus and also amendments to the tax code. So if we see the whole schedule on the 12 versions of the legal rights part, as you see, the last year we had some 4 no's on C, and that have been highlighted with red. So this year we believe that it should be changed all to yes. How? So this is the, now we go one by one. The first question that was reflected as no is that does the law allow businesses to grant a non-possessory security right in a single category of mobile assets in a way that they don't require a specific description of collateral? So we have received the feedback from the Doing Business team last year, saying that even if it's in the law of the law on encumbrance of movable properties, a civil code said otherwise, so the civil code prevailed. And so based on those assumptions and feedback, we made amendments to the civil code. Now, as you can see, the articles 276.1 and 280.2 civil code, and also the 306. They changed in a way that now the law allows businesses to grant a non-possessory security right in a single category without requiring a description. As you can see, this was mainly the 280.2. So now it clearly says that the description of the pledged object may indicate that it consists of all existing or future movable property of the pledger. Such description may also include the specific type of movable property, receivables, or part of thereof. And also, there was obstacle in the pledge of movable assets in turnover, in circulation. So this article was redrafted so that there is no any obligation to keep book of the pledged property, and also you don't have to specify them in the contract. Also, we will give you the new wording of the law so that you can see in detail. So this is the first question. Then the second is one saying that is the general description of debts and obligations permitted in collateral agreements. So all types of debts and obligations can be secured between parties, and also can they specify the maximum amount of the assets that are encumbered. So again, this was the civil code was shown as the main obstacle which prevailed over the loan encumbrance of movable properties. So this article of the 280.2 of the civil code was redrafted. Now, as is part of the previous question as well, now it says that the pledge agreement can in the pledge agreement shall contain the size and also the maximum limit of the obligation, so that you can say, for example, you can either say that this is the pledge of the $1,000 obligation, or you can say it's the pledge of the obligation which is up to $1,000, for example. Now again, the civil code, last year's civil code was amended mainly in a way that now it is in harmony with the loan, the secure transaction law. So the wording of the secure transaction law has been transferred to the civil code. Now it says that all existing or future assets can be pledged between the parties, can be encumbered between the parties. So this is again the answer to the question that all types of debts and obligations can be secured to parties, and they can include a maximum amount of the assets that are encumbered. The third question is the possibility of future or after acquired assets to be the subject of encumbrance, and its extension, automatic extension to the predicts, proceeds, and the replacements of the original pledge. So again, as you can see, there were some articles in the civil code which obstacled the future assets to be subject of encumbrance in Azerbaijan. And so mainly the amendments were reflected in the civil code. So as you can see, those four articles, 278, 280, 391 and 395 were amended in a way that now it's possible for any future after acquired assets to be the subject of encumbrance. And now, as in the law of the secure transaction law, it makes it possible without requiring or without writing in the agreement. So the pledge automatically applies to the product, proceeds, or replacements of the original assets. So again, we'll put the extracts from the civil code in the notes section so you can see the exact wording of the articles. So the last part was regarded as the insolvency in the getting credit. So was it possible to enforce the pledged property in an out-of-court way? So can they sell it in a private tender or not? The last year answer was the no. Yes?
Question. I want to go back to the debts and obligations one.
Okay.
So basically you're saying that the only amendments were done to the civil code, but there were no amendments done to the just asking to the regulations for the operation of the state register for encumbrance of movable property. Is there any?
So we made amendments to the civil code, which included the maximum amount of the pledge. Then we amended the loan encumbrance of movable properties.
So
Now
it's
it's
a new article. It's the same article that was amended because here.
yeah, I think it's Article 21 or something. I don't remember exactly now, but it was 21.1.8, if I'm not mistaken. Okay. So the regulation was not amended still, but you know it's kind of the legal setup in Azerbaijan. Once there's the amendments to the law, all other decrees should be amended to be in harmony with that law. But still, since the civil code prevails over the law prevails over the presidential decree, so they apply. For example, in our registry, in the second part of the day you will see that, in our registry we changed the registry in a way that is written in the law. So we don't expect or wait for the presidential decree to be amended, because once there's in the civil code, once there's in the law, that's okay. So for example, we have made some changes in the registry saying that secured creditor, when they apply the new notice, they can see that, okay, this is the value of obligation. Within the bracket, it says that it's max or its maximum limit.
Okay, so there won't be any changes to the regulations because the law.
No, they will.
There will be.
They will. It has to be.
Okay, do you know when that will pass, or there's no clarity yet?
Let's say within the next months, because it shouldn't last more than 3 months or something.
Just one quick question on this. So this civil code article will apply and cover agriculture completely, right? So no difference with which sectors it applies, right?
Yes.
Absolutely.
Exactly.
As well as future growth.
Because it's crucial for agriculture in order to bring this financial products.
That's why.
Has to develop financial products.
That's why we take into consideration.
Because it will further allow contract farming, for example, warehouses, seeds, and all these products.
Now we accompany other reports to strengthen this direction.
Shall I? Okay, so the last question is about the enforcement in an out of court. So the previously civil code used to say that only the public auction was possible for the enforcement of the collateral, or you should have a notarized agreement between the parties before the agreement was concluded. So now the civil code was amended as per the articles of the Secure Transactions Law. So it clearly says that repayment of a pledge's claim on behalf of the pledged property without application to the court shall be allowed on the basis of notary's agreement, or enforcement of the pledge subjects to which the law of Secure Transactions Law applies shall be carried out in accordance with the procedure established by the law. So it transfers you to the Secure Transaction Law, saying that if you have a movable asset which the Secure Transaction Law applies, you can enforce it in a way that Secure Transaction Law prescribes. Again, the main article was that it was before saying that the only pledged property is realized by specialized organizations only through open auctions in Article 297. Now it says that the pledged property can be sold in auction or in any way in cases specified in the Secure Transaction Law. As you know, the Secure Transaction Law prescribes that the enforcement of the pledged property can be realized either in public auction or any way that the secured creditor chooses. So, to sum up, as we talked about the amendments to the Civil Code mainly, which regarded the legal rights part, also we had made some technical improvements of other laws as well. In the Secure Transaction Law, one new state encumbrances was added. It was about the execution order. So Cabinet of Ministers approved a list of information systems through which the state encumbrances can be integrated automatically to our state registry for the encumbrance of movable properties, but still they can register notices manually. But since we have the information systems, as this state information system should be integrated, so that once, for example, there is a let's say the order of the Minister of Taxes to the banks, so it should be automatically reflected in our register as well. So also there were some technical improvements made to the credit bureaus the last year. So it is mainly for the centralized credit registry. Now the centralized credit registry stopped distributing the information to users starting from the 1st of April last year. Now the CCR is mainly collects data for the supervision purposes. The credit bureau, on the other way, is the only credit register now in Azerbaijan to both collect and distribute the information, credit informations. And also, there was an amendment in this tax code saying that tax authorities distribute information on taxpayers to credit bureaus. So actually, this was in the law on credit bureaus as well. Now it's in the tax code. It's kind of the strengthening the powers of the credit bureau. So this is my presentation for now. If you have any questions, please feel free.